been portrayed in the public domain as a lover of guns and with access to firearms. Having undergone specialized military training, specialized security training, and acted as a private security officer in Middle East, and during 2017 general election, there is a real likelihood that if released on bail, that could create fear and intimidation on potential prosecution witnesses, as it would appear to them that a man with a gun or access to the same, whom they intend to testify against is outside there. In this holding, I find support in the decision by Justice Chiang in Republic versus Ahmed Mohamed Omar and others, High Court of Kenya at Nairobi, criminal case number 14/2010, where the judge had this to say. I would only add that potential witnesses in murder case is similarly susceptible to humanity. He knows that if the evidence it tenders that might lead the trial court to convict the accused person, he also knows that if he did not testify, there were chances that this would lead to acquittal of the accused. Therefore, he is fully aware that if the accused could ensure that the witness did not testify, he might be tempted to do so in order to enhance his self-preservation. If the accused was granted bail and had access to gun, the potential witnesses might prefer to preserve his life by keeping away from giving evidence. By so doing, I'm not saying that the applicant would necessarily go out to threaten the witnesses. While that is a possibility, I'm also saying that the witness could become genuinely apprehensive about giving evidence against a person who had access to gun and who was moving around freely, quote and unquote. That picture emerges of the accused person. So if he's left at large, he might be able to create fear amongst the witnesses. Whether the first accused needs protective custody. The first accused is currently nursing a gunshot wound, which according to the prosecution is self-inflicted in an attempt to commit suicide, which according to the accused is an unfortunate incident when he was shot at. Whichever way you look at it, what comes out is that the accused person is someone under threat of danger, and whereas the same has admitted that he would be able to provide for his own security, I find favor in the prosecution submission that is a man in need of close supervision, and that supervision can only be achieved under protective custody, where effective policing is possible. Whether the needs of accused person for specialized medical attention is an exceptional condition to enable the court granting bail. Whereas the accused submitted that he is in need of specialized medical attention in fulfillment of his constitutional rights under Article 43(1)(c) to the highest attainable standard of health, there is no material placed before the court to show that he is unable to obtain that specialized training while in remand custody. I further find that the need for specialized medical attention can be remedied by an appropriate order by the court should the need arise. Having taken into account the material placed before me, the submissions by the advocates for the first accused, the family and the state, and the authorities in support of the said submission, which I've looked at in detail, I'm certified and find that the prosecution has placed before court strong and adequate compelling reasons to enable me deny the first accused the enjoyment of his constitutional right to bail, which I hereby do. The same shall remain in custody during the period of his trial. Having noted the health conditions of the first accused, I order that the same be treated at Kenyatta National Hospital through reference from the remand prison clinic, and to confirm the said treatment has been accorded to the satisfaction of court, the first accused shall attend mention before the deputy registrar of this court once after every 21 days, at which date the medical officer treating him shall file an appropriate report on his progress. On the second accused, the prosecution raised only two issues against her. That is to say, she is an influential media personality who is likely to intimidate and influence the nature of the case. B, her house is a secondary crime scene, and some potential witnesses are employees whom she has authority over. The following facts emerges from the affidavit by the prosecution and the second accused person. She is a well-known media personality with influential friends, as confirmed by a letter attached to affidavit from the Senator for Nairobi. Her employer is very supportive of her, as confirmed by the letter attached to the Prevail report. She is a mother of one with very supportive family and friends. The fact that she was in love with the first accused is not disputed, as confirmed by affidavit. The only issue in this dispute is whether she is a person who is likely to interfere with witnesses or evidence. The only witness named is the second accused herself, and to my mind, her evidence seems to be related to what the prosecution calls secondary crime scene, whatever that means. As submitted by Mr. Katwal, the accused was arrested 10 days after the commission of the offense, and there is no indication by the prosecution that the second accused interfered or attempted to interfere with the witnesses and or the ongoing investigation, which seems to be only related to the first accused. There is complete silence on any allegation of an attempted intimidation or undue influence on the part of the second accused alleged influential friends. There is also no evidence that the same has attempted to influence the prosecution witnesses before or after arrest. The second accused has indicated that she has fully cooperated with the prosecution since arrest in giving out her DNA samples. The prosecution has only made vague allegations that the accused may tamper with evidence or witnesses. Is she a flight risk? The prosecution had portrayed a second accused as a media personality with very influential friends, as stated herein. She is currently employed, and the employer has indicated that upon her release, she would resume a job. She has a strong social support who would not let her abscond unless they are part of the others not before the court. The accused is a single mother of one child who now more than ever before needs her presence, noting that should she be convicted, one of the sentences which is available is death and or long imprisonment. She needs to be with her child during the period of trial so as to inculcate to him values and memories which will make him a better citizen tomorrow. I would therefore dismiss the prosecution contention that a supportive family could step in to take care of the child, as Article 53(1)(e) places parental responsibility and protection upon the mother and father of the child, and further that the child's best interests are of paramount importance in every matter concerning the child. Whether she needs protective custody. The prosecution submitted that having raised concern about her security and safety while in police custody, she is better off placed under protective custody. To this, the second accused has submitted that she is more safe outside than while in remand. There is no indication that she is a flight risk. At this point in time, the accused is considered innocent, and the court can only restrict her movement if there is enough evidence placed before it to support the contention by the prosecution on the need for a safe custody, which the prosecution has failed to do. There is no evidence tendered to show that she is under any threat of whatever nature, and therefore find this contention devoid of factual support and merely speculative. Whether being a media personality is a ground to deny the accused bail. This court has had to deal with a similar situation where the allegations were raised that the accused should be denied bail because he's a man of means in the case of Republic versus David Mushiri Mwangi, to which the court had this to say: the fact that the accused person is a man of means, in this case read influence in itself, cannot be a ground for denial of bail unless it's proved to the satisfaction of the court that he is using the same means, for this case influence, to defeat the cause of justice, which is not the case herein. Save for the fact that the second accused is alleged to be an influential media personality, no material has been placed before the court to show how she is likely to use the media presence or influence to defeat the cause of justice. While the influence of an accused person may be a ground to deny bail, the state must place before court enough material to support that contention. The accused is still presumed innocent till the time the guilt is proved, and as per bail and bond policy guideline, she has all the rights to maintain her social status and fabrics. Ms. Moniki, for the prosecution, urged the court to put restriction on the second accused, and in particular her presence on TV screen. I've noted that these are noble points which has not been tested in our jurisdiction, and from the submissions before me, I know that is a complex and substantial matter which needed bail hearing so as to test whether or not the presence of the accused on a screen would intimidate or interfere with witnesses so as to affect the administration of justice. At this stage, however, it must be noted that the accused is still presumed innocent, and the court must guard against making orders which might be perceived to be confirming that she is guilty in the eye of the public. The bail policy guideline under General Principle 3.1 states that the accused should be allowed to keep the fabric of her or his life intact by maintaining employment, family and community ties, and any order which the court makes in this regard ought not to be so strict so as to be incapable of compliance, thereby making the grant of bail illusionary. It is for the judge to introspect what might be the right thing to do, always based on the facts, but without leaving behind compassion. I should therefore comment on this further while setting out bail terms in respect of the second accused. Whereas at this stage the court is not required to go into detailed analysis of the prosecution case which has not been presented before the same, the court must look at material placed before it by the prosecutions, and from the affidavits of the investigating officer, it comes out that the role of the second accused relates to what allegedly took place in her house, which they have termed a secondary scene. The second accused, on the other hand, is so sure of her innocence that she is convinced that if she were to be convicted, she will only be convicted on offense of being in love, which is not a known offense under the law of Kenya, which is not a known law under the law of Kenya. Though I take cognizance of the fact that love can make people do very strange things, as I'm told that in the Bible, one person called Adam, knowing very well the law of God and the punishments for eating the forbidden fruit for the love of his wife, Adam went ahead and ate the same so that they can die together if they must. I think I've said enough on the issue of the stability of the second accused to be granted bail, as the decision to grant bail or refuse bail is only based on probability and no certainty. And since our courts are not gambling odds but forums for discovery of truth based on the relevant material placed by both sides before the courts and the authorities in support, I'm unable to agree with the prosecution that as factors presented individually or cumulatively raise a possibility that the second accused would abscond, interfere with witnesses or evidence, or influence the nature of the prosecution case against, or to act in any manner prejudicial to our intended trial. I therefore find and all the other prosecution has not placed before the court compelling reason to enable me to deny the second accused the enjoyment of a constitutional right to bail, and those advanced can be adequately accommodated by relevant bail terms and conditions, and order that the second accused be released on bond pending trial and determination. What now remains is to set out bond terms and conditions. The starting point being the constitutional injunction that the terms must be reasonable. On behalf of the second accused, she has deponed that a sum of Kenya shillings 350,000 cash bail with one surety or two surety of similar amount would be reasonable, taking into account the humble circumstances of herself, family, and relatives. The state and the family of the victim were silent on what would be reasonable terms. The Constitution is silent too on what are most reasonable bail terms, but the court must take into account the nature of the offense, the likelihood punishment on conviction, and the likelihood of accused in honoring bail terms if granted. In this matter, the life of a young Kenyan girl was lost, and the offense has pricked the heart of the nation on how it was committed and has attracted wide media coverage. The paramount obligation is to issue bail terms which will make it necessary for the second accused to attend a trial if and when the case is fit for hearing, noting as stated herein that one of the punishments upon conviction is death. Sentences and bail terms must make it hard for the second accused to abscond at trial. Guided by the principle set out by this court in Republic versus David Mushiri Mwangi, I am satisfied I'm satisfied and of considered opinion, and all that a bond of Kenya shillings 2 million will be very reasonable. I therefore order that the second accused be released on the following bail terms: a bond of Kenya shillings 2 million with one surety of a similar amount, or in the alternative, cash bail of Kenya shillings 1 million with 3 sureties of similar amount. The second accused shall not make any contact with any of the prosecution witnesses, either directly or indirectly, until final determination of this case. The accused, upon a release on bond, shall, in the presence of an advocate, accompany the investigating officer to a residence where the said investigating officer shall, if not yet done, take inventories of any evidential material thereat, including taking photographs and graphs, before being allowed an exclusive access thereto. Finally, on the issue raised by Ms. Mwaniki, and having stated here in that's a novel area, and taking into account the fact that the second accused had the misfortune of reading the news in respect of the deceased death, I'm of the considered view, and all that some limited restriction is necessary, is reasonable and justifiable. I therefore direct as follows: the accused shall not read news, comment, or participate in any interview directly or indirectly related to this case. The accused shall not read news during the period this matter is fixed for hearing. The accused shall not interview any parties directly or indirectly connected with this case, including the victim's family, the advocate, and the prosecution witnesses, and including the trial court. This order is subject to review by the court from time to time, and it is so ordered. Just a minute, we need to do administrative matters first before.
Na mtazamaji, ndivyo hivyo kikao cha kusikilizwa kwa ombi la dhamana la Jackie Maribe na Joseph Irungu maarufu Jowie katika mahakama kuu hapa nchini. Na kwa kifupi tu ni kwamba Jaji James Wakiaga amemruhusu Jackie Maribe kuachiliwa kwa dhamana ya bondi ya shilingi milioni 2 na mdhamini sawa na kiasi hicho, au shilingi milioni 1 pesa taslimu na mdhamini sawa wa kiasi kama hicho. Kwa hivyo Jackie Maribe atakuwa akiachiliwa kwa dhamana, lakini Joseph Irungu atakuwa akisalia rumande kesi hiyo itakapokuwa ikiendelea. Na ametoa sababu nyingi tu za kutoa uamuzi huo ambazo tutakuwa tukiziangazia kwa kina zaidi katika taarifa zetu za hapo baadaye, tukianzia kwa taarifa zetu za saa 7 ambazo zinakujia muda mfupi kutoka sasa. Kwa hivyo picha unazoona za moja kwa moja baada ya kikao hicho, bado shughuli zinaendelea pale. Kwa hivyo kinachojiri kwa sasa, habari ambazo zimejiri kutokana na kikao hicho ni kwamba Jackie Maribe atakuwa akiachiliwa kwa dhamana, lakini mwenzake ambaye ndiye mshukiwa wa kwanza katika kesi hiyo na wakabili wawili hao kuhusiana na mauaji ya mfanyabiashara Monica Kimani ambaye ni Joseph Irungu atasalia rumande kesi hiyo itakapokuwa ikiendelea, kwa kuwa jaji anasema kwamba anakisiwa kwamba huenda hata shirikiana na wale ambao wanajihusisha na upelelezi wa kesi hiyo vikamilifu. Lakini amesema kwamba Jackie Maribe kwa sababu alishirikiana nao vilivyo na vile alipata kubali hata kutolewa zile chembe za DNA na mengine mengi, basi ataachiliwa kwa dhamana. Tusikie bado kauli 2-3 kutoka kwa mawakili.
They report in a week's time from today on whether the accused person has been taken to the hospital and the required surgery done with harm to avoid other implications which cannot be delayed anymore, Your Lordship. Thirdly, Your Lordship, I will be praying that if the prosecution, who can state right here before the court that they do not require the personal effects that were taken from the accused person during the arrest, that is including his mobile phone, then the same to be released immediately, including the clothing and all the personal effects that were collected, to be released immediately to the accused person. And lastly, Your Lordship, now bearing the circumstances, if you would really oblige us, you can give us an early hearing date for this. The earliest that you can have, Lordship, so that we can hear this. That's all.
Mr. Kato, anything you want to say?
My Lord, I have a few requests to make. First of all, my Lord, we are obliged to the ruling and we are grateful. The second one, my Lord, is that on the 15th of October 2018, when the plea was being taken, we were promised witness statements within 14 days. Personally, and I'm aware also the counsel for the first accused have continuously requested both the investigating officer and the office of the DPP, both orally and in writing, for the witness statements and the documents, and so far they have not been supplied, even against the face of the fact that 2 weeks have expired.